So you got a cease and desist letter accusing you of infringing somebody's patent. Now what do you do? My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please do me a favor and like, follow, and share. Okay. Before patent infringement lawsuits are initiated, it is not uncommon for the patent owner to send what is called a cease and desist letter to the party they believe is infringing their patent. So if you're making products, you could find yourself the unlucky recipient of one of these communications on some law firm's letterhead, accusing you of all sorts of infringement and saying that you owe their client damages and demanding that you turn over all sorts of information and that you comply with this request by a certain time, et cetera, et cetera. At the risk of sounding self-serving, this is not an area where you want to engage in self-help. I know a lot of you guys watch these videos to try to figure out how to do all this stuff yourself. You know, you do that at your own risk. That's your thing. But this is not the place to do that. You can get yourself into real trouble, and you definitely don't want to ignore the cease and desist letter. So you've got to find a patent attorney, and in my view, someone who's got some litigation experience, who knows how these things play out if they get to court, to help you through this process. Now, what are you going to actually do with the attorney? Well, I mean, the first thing really is, what's your bottom line here? Like, is this something worth fighting for? Is this something you have the resources to fight if it does actually go to litigation? Like I said in an earlier video, patent litigation is expensive. I've heard it called the sport of kings. And you may not have the wherewithal or the resources to actually fight a patent lawsuit. Or are you just going to sort of surrender? Do you want to just give up making the product and hope that they leave you alone? And then, you know, you have to figure out what you're going to do if they start demanding information. And there's a lot of demands that are ridiculous in some of these cease and desist letters. But one of the points I want to emphasize is that, you know, some of these law firms, especially these bigger ones that think that they're going after someone who's unsophisticated, pardon my French, but they'll bullshit you in their cease and desist letters. They will take positions on the law that aren't right. They'll mischaracterize their own patents and what they cover. I've seen all sorts of things. So they really have to be scrutinized. You can't take what they say at face value. And no matter what resolution you ultimately think is the one you need to get to, you want to come to it with a position of strength. You know, I mean, if you're going to surrender and not make the product anymore, well, you don't want to just, you know, say I surrender and have them demand all sorts of money from you and demand discovery of all your information. You know, what you want to do is come in the process with leverage. And what I mean by that? What I mean by that is you want to come back with arguments about why they're wrong, either with respect to their assertion that the claims are infringed or because their claims are invalid. And, you know, it can take some time to do that analysis. Sometimes you have to do some prior art searching. It definitely involves reviewing the patents and the accused products and the file history carefully. So it takes some time. So you don't want to sit on this sort of thing, because if you don't say anything, they're going to file a complaint and they're going to say, well, they just ignored us, and they're going to make you look like a bad actor for not respecting the intellectual property rights of other parties. So, you know, I wish I could tell you there's a simple solution. You can just go do this yourself. This is not one of those areas that you can do that. You know, they'll make demands for information that they have no right to outside of the litigation process. And you just need someone who can guide you on, you know, what's reasonable, what your real downside risks are, and help you push back. So I hope that helps to keep you out of trouble, and I hope to see you here soon.